Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 132 of the NCDWI Guy podcast. On today's episode, we are talking about the recent North Carolina Court of Appeals decision, State versus Eagle. Very interesting analysis of seizure in relation to a traffic stop that is based on a case that ultimately resulted at the Superior Court level in a DWI conviction, overturned by the Court of Appeals, finding that there was no legitimate reason for a stop and that the seizure occurred prior to there being any reasonable suspicion. So very interesting. We're going to go through that case. But before we get into State versus Eagle, I always am trying to keep events out there, CLE opportunities, education opportunities for everyone to have on their radar. And the North Carolina Advocates for Justice on December the 2nd is hosting Criminal Masters in Advocacy, holding the state to their burden, making the state rule out all reasonable doubts, basically a CLE on reasonable doubt. And the reason I'm recommending this is I went to a very similar, if not identical, presentation by David Ball and Artemis Malkapour, who are presenting at this CLE on December 2nd. I went to a similar CLE on ruling out reasonable doubt that they put on a few years back through the NCAJ, and it was phenomenal. I mean, it was really helpful in terms of thinking about how to communicate reasonable doubt to your jury. It was one of the best CLEs that I've ever been to. So I would highly recommend that. Again, I don't know that this is going to be the exact same content. I'm sure that it's either been updated or maybe even taking it from a different angle, but was a very powerful CLE. So I'm sure that this is going to be a good one. So I believe it's both in person and virtual, but go check that out on the NCAJ website, ncaj.com. So to dive into State versus Eagle, I absolutely love this decision. And it's not just because the outcome is defense friendly, although that certainly doesn't hurt. It's always good to see a win at the appeals or Supreme Court level. So that's always a good thing to see. But the reason why I think this is such a great decision is extremely well reasoned. And I believe that this would be a great case to have kind of ready to pull up anytime that the state is arguing community caretaking or whether or not a consensual encounter has occurred. This would be a great case to just read some of the language from to basically put out to the judge a seizure had occurred, the person would not feel free to leave, and make it very clear that your client has been stopped and reasonable suspicion either needed to be had or wasn't present, whatever it might be. The court in this case specifically noted that the community caretaking exception was not argued by the state or referenced by the Superior Court that reviewed the case. And so they didn't really consider the community caretaking doctrine. So again, that wasn't specifically at issue in this case, but the logic applies if you have a community caretaking situation going on in your case. So even though they specifically say this is not the reasoning and this is not based on community caretaking, it very much would be a good case to have at the ready if the state is arguing a community caretaking exception applies in a fact situation that is appropriate to that argument. So the court spells out the issue in the case right from the get-go, and that is whether a driver is seized within the meaning of the Fourth Amendment when a police officer in a marked police cruiser drives slowly past a parked vehicle at night, backs up, pulls in behind the vehicle while activating the patrol car's blue lights, blocks the driver's exit, and then remains in the police cruiser while checking defendant's license plate. And the answer to that is that, yes, a seizure had occurred and that the court found no reasonable suspicion existed in this case. Therefore, the Fourth Amendment was applicable, a seizure had occurred, and that there was no reasonable suspicion for stopping. So to just kind of get into a few brief facts, Deputy Belk of the Orange County Sheriff's Department was performing nightly business checks, driving around looking at businesses, and noticed that the defendant pulled into a driveway of the Maple View Agriculture Center. It was a gated driveway, so the defendant pulled the vehicle kind of up to the gate off the roadway, but the business was not open. This was at nighttime around 3 a.m. And the officer, the patrol officer, basically had been kind of following the defense vehicle, sees the defendant pull into the driveway this way, starts to pull past the driveway, but doesn't get all the way past the driveway. And then the officer backs her vehicle up and kind of partially blocks the driveway exit that the defendant could have pulled out of. Activates blue lights. The officer indicated that she activated blue lights because her vehicle was partially in the roadway. And so as a safety precaution, she activated blue lights. So this was, according to her, not a blue light stop related to the defendant. The reason the blue lights went on was not because of some sort of seizure of defendant's vehicle. From her perspective, it was a safety piece. Sat there for about a minute in the vehicle before exiting, was in uniform, had her gun exposed, was the only officer on scene when she exited the vehicle, and then went up and approached the driver. The state argued that the seizure did not occur until the officer collected the defendant's driver's license. And by that point, she had noticed slurred speech, red glassy eyes, odor of alcohol. So as soon as the defendant's window went down, or door, I don't actually off the top of my head remember which one it is, but as soon as there's contact with the defendant, odor of alcohol, red glassy eyes, slurred speech, and so the state said, well, yes, then she collects the driver's license, but at the time that she collects the driver's license, she had reasonable suspicion based on these personal contact clues of odor, red glassy eyes, slurred speech. The defense argued that no, a seizure has occurred at the point of the officer approach because of the way that the officer had parked her vehicle, partially blocking the driveway. There had been a seizure. Nobody in the defendant's position would have felt free to leave under these circumstances. And so the court very thoroughly goes through the Superior Court's findings of fact, conclusions of law, and then talks about the Fourth Amendment and the Fourth Amendment requirements in terms of when a seizure actually occurs. The court notes that not every interaction between citizens and law enforcement constitutes a seizure. The court in State versus Eagle does a really good review of the Fourth Amendment, both at the federal level and North Carolina level, in terms of cases that discuss when a seizure has occurred. The court, in its holding or in its opinion, says, in contrast, a seizure occurs when the officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen. A show of authority constitutes a seizure when, under the totality of the circumstances, a reasonable person would feel that he was not free to decline the officer's requests or otherwise terminate the encounter. In determining, the court goes on to say, in determining whether a show of authority has occurred, relevant circumstances include the number of officers present, whether the officer displayed a weapon, the officer's words and tone of voice, any physical contact between the officer and the individual, whether the officer retained the individual's identification or property, the location of the encounter, and whether the officer blocked the individual's path. And cites State versus ICARD 363 NC app or NC 303 Supreme Court. So the court again goes through this, and likely if you've had any of these type of seizure cases, whether or not the person is free to leave and those factors that kind of help determine whether or not a seizure has occurred, you're familiar with those. But what I kind of wanted to go through a little bit more in detail was the court's reasoning for its decision. And this language is just so beautiful because it really points out the flaw in the argument that you often see when the state says, well, the person could have just disengaged. The person could have just ended the encounter. And you see some really poor decisions, I would say, when it comes to this free to leave standard, in terms of any normal person looking at the situation will say that person can't leave. And there being some rulings where it's just bizarre why the court has concluded that somebody would feel free under these circumstances to leave. But what is beautiful about this language in State versus Eagle is it really spells out why this is an issue. So there's two primary things that the court points to that I think are helpful if you have any case like this, to point out to the judge. And the first is that if the person ends the encounter, kind of mistakenly believing that they don't have to oblige, they face potential criminal prosecution. And the court specifically points to the charge of resist, delay, and obstruct an officer carrying out their duties. So if a person with blue lights behind them or near them and an officer approaching just decides to drive off, it is really likely that person is going to get immediately pulled over and possibly charged with a criminal offense for, again, not complying, right? Again, whether this initiates as a welfare check or a community caretaking exception is being argued, a consensual encounter, whatever the circumstances may be. This is an important fact to point out to the judge, that if my client had not complied under these circumstances, judge, my client risked potentially facing criminal charges for not obeying officer commands. And again, maybe he's misinterpreting that, but let's be kind of reasonable and err on the side of caution in terms of somebody sitting in their car under these same circumstances. So number one, they point out that a person that misinterprets whether a stop has occurred or not and just decides, well, I'm just going to drive off, potentially faces prosecution for not following officer orders. But secondly, and more importantly, and this is the real beautiful part of this, is that if the person doesn't comply with the stop, things can escalate rather quickly. So in this situation, the court basically said, had the defendant who is parked against the fence, basically the only way they can go is out past the patrol vehicle. And the court seems to indicate in the opinion that there was room enough, even if it would have been a tight squeeze, there was room enough for the defendant actually to get out of the driveway to this business, that they weren't completely shut down, that they could have gone around. But in reality, what happens if the defendant decides to do that? So as the state is arguing, this is a consensual encounter, Judge. At any time, the driver could have just, basically put that car in reverse or put that car in drive and taken off, right? That's the argument that you hear from the state on these type of consensual encounter, welfare check case. They didn't have to wait around. They could have just left. They didn't need to stick around and talk to the officer. They could have broken off the encounter at any time. Well, if that's true in this case, what do we potentially risk? Well, we potentially risk a wreck of the defendant backing into the patrol car, potentially backing into the approaching officer, the officer misinterpreting this situation and getting nervous. The defendant is going to do something silly or crazy, because it would actually be pretty wild for somebody to back out under these circumstances, and possibly drawing their gun or escalating the encounter from the police side of things. So the court says you have to take all of that into account. This, instead of this just being characterized as this consensual encounter where the defendant can basically break it off at any time, if we don't see this as a traffic stop and we say, yeah, person can leave, that can escalate things rather quickly in a way that we don't want to encourage them to be escalated. So I'm just going to read a little bit of language from this, because I think it's really important. So a couple of just parts of the decision. We agree that when an officer blocks the defendant's car from leaving the scene, particularly when, as here, the officer has followed the car, the officer demonstrates a greater show of authority than does an officer who just happens to be on the scene and engages a citizen in conversation. Different situation when you've got a car that's blocking defendant's vehicle. Moreover, a reasonable motorist would surely feel less at liberty to ignore the police presence and go about his business when a police officer in a marked police cruiser pulls in behind her while activating the blue lights and blocks her exit. In fact, in such a situation, most people would feel compelled to remain in their car and wait to speak with the officer, knowing that attempting to leave would only end in trouble and/or danger. This pressure to comply becomes especially apparent when examining the criminal consequences that might follow if a person ignores an officer's blue lights. And again, the court then goes on to talk about North Carolina General Statute 14-223A, resist, delay, and obstruct charge. The court points out that when a person would likely face criminal charges for failing to comply with an officer's request, then that person has been seized within the meaning of the Fourth Amendment in Article 1, Section 20 of our state Constitution. So the court says when there is a potential for criminal charges, you have to take that into account. If this is going to be seen as resisting, delaying, and obstructing, you have to take that into account. And this is what I really don't get. Anytime that there is blue lights kind of near the defendant, even if the driveway or whatnot is not blocked, to just assume that somebody can just basically, put their car in drive and be on their merry way without any further police interaction, I think that is just so ridiculous. I mean, it just is so absurd to think that there's not going to be any police interaction at that point, and the risk of facing criminal charges is very real. The court goes on, as we just kind of talked about, but I'm going to read from the holding so that you can see exactly what the court says. Furthermore, we do not want to suggest to the public that when an officer pulls behind them at night while activating their blue lights, stays in the car for a minute, and then begins to exit the vehicle, that they are free to attempt to back out of the situation as long as they do not make contact with the officer or drive in their direction, which could be considered an attempted assault. Such actions run the risk of escalating the situation, causing an officer to understandably feel threatened and potentially result in a car chase or the use of deadly force. The court says the state implicitly argues that this defendant was free to try and back her car out of where she was stopped, either while Deputy Belk sat in her car running defendant's license plate or even while the defendant walked up to the defendant's window. Given that this incident took place at night in a rural area with no lighting, we do not know what would have happened if defendant had reversed her car toward Deputy Belk or the patrol vehicle in an attempt to leave the scene. Perhaps defendant might have hit Deputy Belk's patrol vehicle, or worse, defendant might have accidentally struck Deputy Belk when she was approaching defendant's car door. Perhaps any attempt by defendant to leave would have made Deputy Belk feel threatened, leading her to fire her sidearm. Either way, what started as a simple traffic stop could have escalated to something much worse. Defendant made the only safe and reasonable choice available by remaining in her car at the scene. I'm going to say that again. Defendant made the only safe and reasonable choice available by remaining in her car at the scene. The state's argument is not only illogical, but it is also potentially dangerous. That language is beautiful. Read that language in a case where the state is arguing a consensual encounter. Read that language because it really puts into perspective what happens should the defendant in a lot of these cases decide that they are just going to, as the state says they can, or theorizes that they can, just break off the encounter and leave. Think about the impact that decision has. So that is just, I think, really powerful language. The final thing that the court just does wonderfully, and I think is so cool and powerful in terms of the language of the court, is the court ultimately looks at this situation not from kind of a third party view, but from the perspective of the defendant. And that is the important thing to do when you're arguing, would a reasonable person in the defendant's shoes have decided to leave? Would they have felt free to leave? That is the essence of the free to leave test. Would a reasonable person standing in the defendant's shoes have felt free to leave? The court concludes its decision with this, or this is one of the final paragraphs. This isn't the last paragraph, but towards the very end of the opinion. In sum, when one examines all the attendant circumstances surrounding this encounter, the only reasonable conclusion is that defendant was seized by Deputy Belk, especially when one examines this encounter from the perspective of a reasonable person in defendant's position. Around 3:19 a.m. on 14 November 2019, defendant was lost and pulled over into a short driveway that was gated and locked. The street was completely empty aside from the defendant and Deputy Belk, and it was dark due to the absence of street lights on a rural road. Deputy Belk drove slowly past the driveway, only partway past the defendant's car, put her patrol vehicle in reverse, and slowly backed down the road. Deputy Belk pulled partially into the driveway, activating her lights as she did so, and stopped behind defendant's car, impeding defendant's ability to back out of the driveway. We are not expressing the view that Deputy Belk did anything wrong, and it may be true that she did not believe this was a stop. However, when analyzed from the view of a reasonable person in the defendant's position, even at this early point in the encounter, any reasonable person would have realized that they were the target of police suspicion and were likewise not free to drive off. To hold otherwise could instigate the escalation of encounters between the police and drivers in North Carolina and lead to far worse results for those involved. Beautiful language because it really explains not just from this theoretical side of things. Well, does the person feel free to leave or do they not feel free to leave? No, in real kind of meaty language, it explains the public policy behind the free to leave test, why it is important, why this acts as a safety hazard, why it's not fair to put the defendant in this position where they're wondering if they're going to suffer criminal prosecution, as they likely would if they drove off. It basically puts all of these public policy considerations into the argument. Very well reasoned, very well written. I love the examples that are given, spelling out why these things are important. And again, use this case if you have a situation where the state is arguing a consensual encounter occurred, that the community caretaking or welfare exception, welfare check exception apply. Use this case to argue from a public policy perspective that is now in North Carolina law, why your client was seized and why no reasonable suspicion existed at the time of that seizure. Hope this has been helpful and look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.